Welcome to this webinar on how to stop late payers and reduce debt exposure. Within the construction industry, it's not really something that I need to spend a long time introducing. Late payment is very prevalent, bad debt's very common, and of course cash flow is the lifeblood of the industry. So without further ado, let's get straight in to the topics for today. And basically, I want to structure my talk into two broad segments. So the first thing I want to look at, and it's really where I want sort of the emphasis of this talk to be, is on the management techniques, the things to look at in order to minimize the chance of bad debts in the first place. The old sort of prevention is better than the cure. And then once we've looked at that, then we will have a look at methods to recover bad debts or disputed debts. So in looking at ways to try and avoid bad debt in the first place, what we're going to do is we're going to have a look at sort of it around the contract. So pre-contract, kind of at contract when you're at negotiation stage, and things to do post-contract. So let's have a look at sort of the pre-contract stage. And one of the key questions, and it's, it's a very obvious thing. A lot of these points I'm going to make are very obvious ones, but they're still very important. Is who are you doing business with? Now there are a number of sort of paid for services out there. I've put CreditSafe as an example on the slide. I'm not endorsing them. They're just one of the many companies out there, and these companies will have their own processes, but generally they seem to go to Companies House, they take the accounts and financial information available, they may have some other sources, and then they present that to you in kind of a more palatable way. They'll give them a score maybe out of 100 as to how credit worthy they are, but you can sidestep that sort of paid for system and just go straight to Companies House. Companies House these days is very good. All of the filings are there for free, and those filings will include things like the charges and the accounts. So I want to just touch on some things to look at when you're looking at accounts on Companies House, without trying to be an accountant and give you an accountancy course on how to read a balance sheet. But look at the accounts, obviously to see the financial health of the business, what reserves they have, shareholders, funds, turnover, all of that kind of stuff. But when doing so, be aware that the accounts will obviously present an old snapshot. It's generally how the business was doing a year ago. And when thinking about that, be aware of things like accounts that may predate March 2020. We were less impacted in construction than some other industries with the lockdowns for COVID, but it does still affect the construction industry, things like supplies, labor, etc. So a company pre-COVID could be completely different post-COVID. So if those accounts are old, then you need to be cautious. Another thing to look for is whether a company has changed its accounting reference date. Now, say I'm not an accountant, but I'm told that by filling out a very sort of simple form and filing that with Companies House, you can effectively buy yourself sort of an additional 6 months in which to file your accounts. Now, sometimes there's a very legitimate reason for that. So, for example, a group company may want to line up all of the group companies' accounts so that they're all done at the same time to make life easier for themselves and for their accountants. But sometimes people do it just to sort of prevent showing their financial cards to the world for another 6 months. So it's something to look out for, and it's something to cause you to raise an eyebrow if it's been done for no apparent reason. Another thing when looking at Companies House is to look at the charges, the first, second charges, sort of debentures, because these, and we'll come on to it later on in the talk, if you're an unsecured creditor, then if the company becomes insolvent, these charges are going to trump your debt. Basically, the bank will be taken care of first, any other sort of lenders will be taken care of first, and you'll come at the end, and there may not be enough money to pay you and the other creditors. So charges are a thing to pay attention to. Also on the subject of charges, sometimes you will see debentures, which are sort of fixed and floating charges over all of the company's assets from factoring companies. Now, factoring companies basically will pay their clients, your potential clients, their invoices pretty much straight away. But in return for doing so, they'll take a cut off the top of that invoice, and they will then go and pursue sort of the ultimate payer for the money. Now, if the ultimate payer doesn't pay straight away, then they will then charge your potential client, sometimes penalty charges, sometimes interest. And so whilst there are legitimate reasons for factoring, and many good companies do it in order to sort of improve their cash flow, I do find it a very common factor in businesses that are failing. And out of desperation, a business will go to a factoring company and say, well, look, you pay our invoices straight away, and in return you get a cut for that. Well, I often find that that cut can be quite substantial and is often more than the profit that can possibly be made on a job. So companies do get into death spirals with factoring. And so, as I say, I'm not trying to bash it. There are good reasons for it, but again, for me, it's a red flag and something to look for in people you're potentially doing business with. So sticking with the topic of who you're doing business with, your relationship with them. Do you have a pre-existing relationship? Have you worked with them before? That will be a very good source of information as to whether they're a good payer, they're a bad payer, they may be difficult to get money out of. And whilst, of course, sort of past performance, the fact that they've been good in the past doesn't mean you should necessarily drop your guard. It is a good indication of how they will be in the future. If you do have a relationship with them, how much work do you do for them? I've had a few clients over the years who have come to me with disputes, but then when you ask them about their relationship with their client, it turns out they do too much work for them. For example, they may work 100% for a local authority. Now, in the case of working for a local authority, a local council, it's unlikely that you're going to have a truly bad debt. The council will have the money to pay you, but it can be quite common to have a disputed debt. And in some cases, a disputed debt can be as bad as a bad debt if the dispute is significant enough. And where you've only got one client or a client that is too important to you, it basically gives you no room then when it comes to escalating the matter to disputes. Your negotiation position is incredibly weak, and so it can leave you terribly exposed. So do be aware of how much work you're doing for a particular client. Then look at their risks. For example, the type of work. Are they doing an unusually complicated project? Is the project unusually large for them? Because you'll find that if those are sort of the case, then they will struggle to manage the project. They may struggle to resource it, to provide you with the information that you need. You may find your work being delayed and disrupted by them. And if they are struggling, then it's unlikely that they're going to get financial recovery from their client. And so basically they'll look to pass the pain down the chain to you. So that can lead to payment disputes and bad payments. Program as well is something to consider. Do not sign yourselves up to a job that can't be delivered on time. There's certain sort of industries in particular, for example, student accommodation, where you've got to hit that September date to get the students in by, that if it's missed, then potentially the developer, the student accommodation provider, is left with that revenue for a whole year. And so the financial penalties can be pretty massive. And if your main contractor, your client's being hit with those financial penalties, then they're naturally going to look to try and pass them down the chain to you, even though it may not be your fault. So program is something to bear in mind. And of course, once you've looked at their risk pre-contract, then you want to be looking at your risk And the time really to really focus on your risk is at the contract stage. So you know, you're fairly comfortable with the overall scheme. You're fairly comfortable that these people are creditworthy. So what about your contract? Now, a construction contract has many elements to it. You know, the main sort of things are price, scope, and time, very broadly. But there's a whole host of other things which I can't go into in this talk because we'll be here for forever. But generally look at your risk level, and if it is a highly risky contract, then you need to be rewarded. It needs to be worth your while, or you may need to walk away from it. Looking specifically at terms that can be in the contract, the payment terms. Now, obviously, this is important when it comes to managing debts and payments. So, how long is the payment term? You know, is it sort of 30 days, 60 days? You know, 30 days is fairly common, so that you're in a monthly cycle. Some will do it within 14 days, and you'd actually expect sort of labour-only contracts to sometimes be weekly payments. I remember Carillion had 120-day payments, and I sometimes see 90-day payments. So you've got to ask yourselves, if this company is asking me to hold off payment for months, then why is that? What are they doing? Why do they need such a long period in which to hold my money? And it should be ringing alarm bells, because basically they're running the job off your money. They are getting you to cash flow it, and you know, it's going to be a major red flag if the period is unusually long. When talking about the periods, you need to bear in mind that because the way the construction legislation is sort of structured at the moment, and again, that's kind of beyond the scope of this talk, you often see 2 periods for payment. So there'll be a trigger, and usually that trigger is you putting in your application. And there'll be a period then to the due date. Now, the due date, pretty typical in construction legislation, has to be said, it's just badly named. Really, you could perhaps call it the valuation date. And the due date is when the other side will often have to provide you with their notice, with telling you basically what they're going to pay you. They've got to do it within 5 days of the due date. You'll then see a second period from the due date to the final date for payment. Now, the final date for payment is when you'll actually get your cash. So be aware, because I often see the due date kind of put quite prominently in the contract, you know, 30 days to the due date. But then when you look into the T's and C's, you'll find that, you know, there's another 14 days or maybe even another 30 days to the final date for payment. So rather than being on a 1 monthly cycle, you're actually on a 2 monthly cycle. So do be aware of that. Is there a payment schedule in the contract? If there is a payment schedule, then that is generally a good thing. You know, I'm very pro payment schedules, provided, of course, that they've been put together properly. But a payment schedule lets you know where you are. It lets them know where they are. You know that you need to get your application in on a particular date. You know when you're going to get your payment notice, and you know when the cash should hit your bank. And you can then hold them to that, and we'll come on to that a bit more shortly. So payment schedules, I would say, are a good thing to include in contracts. Look at how and when you apply for payment. So obviously the when may be dictated by the schedule, but how do you apply for it? Sometimes you'll see particular email addresses that you have to use. Sometimes you need to send it via hard copy post, and the construction legislation at the moment, with sort of the payment notices, the pay less notice, you know, the potential for a smash and grab if a payer ignores your application. Essentially, the case law over the last few years has been that if you, as somebody receiving payment, want to take advantage of those automatic provisions where if your work hasn't been valued, you basically get 100% of what you've applied for. If you're to have the benefit of those provisions, your own application needs to be correct. So if you have signed up to things which you need to provide, then do make sure you provide that backup at the time of applying. Also, looking at the time when you sort of enter into the contract, you know, that at contract period, when you're negotiating, I specifically want to talk about retention. because the amount of sort of disputes, which shouldn't be disputes, I get on retention is very large. Some main contractors, quite frankly, see it as their money. Some have, I think, deliberate policies of getting the subbies to work hard to get their retention back. So first of all, how much is the retention? Now, 3% or 5% are typical, but don't fall into the trap of thinking just because they're typical that there's a rule of law that means it can only be that much. The amount of retention is what's written in the contract, and I have seen it be 10% and higher, which can kill the profit in a job on an interim basis. So first of all, what is the amount of the retention? And then what's that retention being held back from? So the purpose of retention, of course, is so that an employer, a main contractor, can get back the company that's doing the work if there's any defects in them, or if the company that did the work doesn't want to return, they've got a pot of cash that they can use to employ somebody else to put right the defects. So, for example, you shouldn't have retention on scaffolding works, on temporary works that just simply won't be around in 6 months' time after the job is finished for there to be defects in. Another thing is if you're signing up perhaps to a design and build subcontract or a design and build contract, you may have a large amount of design fees within your scope of work. So if you have, let's say, a £500,000 contract, 100,000 of that is design fees. Well, if you have one fixed lump sum for 500,000, you'll be paying the retention on that 100,000 of design fees, which I would say you shouldn't do, and it's perhaps best to separate out the design work so that you're not paying retention on it. Key thing in terms of the bad debt sort of context is when are you going to get that retention released? So again, it's very typical for half the retention to be released on practical completion, but it's not always the case. I have seen contracts where 100% of the retention is kept until the end, and that end period is usually the end of a rectification period, the end of a defects liability period. They're called various different things, but there's usually that period in which the contractor needs to return to attend to defects if they're asked to do so. And typically it's sort of 6 months, 12 months, 24. But I do see it going beyond 24 months frequently, because the key thing is, when does that period run from? Now, you'd naturally think that the retention period runs from the practical completion of your works, and that's what it should be, in my view. But you'll often see subcontracts try and push that period out to starting when the overall project has reached practical completion. And that can be a nightmare. If you are, let's say, a ground worker and you're in at the start of a very large job, your groundworks last 3 months. Well, the building itself could take 3 years to build. And so you're looking at sort of the 3 months you were on the job, then the 3 years it takes the main contractor to actually build the building, get all the M&E commissioned, etc. And then your retention period is starting. So yeah, it's something to be very mindful of. Is when does that retention period run from? So once you've sort of got all of that clear, you're happy with all of that. How will you collect the retention? And there can be requirements on you to make an application in the same way that you would an interim payment. So you need to be conscious of any sort of hoops that you've got to jump through. But I would say with retention, one of the most important things is diary management. So when you start the job, if the job is programmed to be 6 months, well, put a note in your diary, 6 months from now, have we finished the job? If you have, then great, have a look at when the retention would have been triggered. If you haven't, then ask your site team, when are we likely to finish? Put another note in your diary, move it on. And then when you finish the job, when you hit your PC, whatever trigger date there is for the retention, then put a note in your diary, 6 months, 12 months, whatever it is from that date, so that you don't miss chasing it. It's very obvious, it's very basic stuff, but you'd be amazed at the amount of clients I have who just don't do that basic stuff. And 5% on every job across the course of many years can mount up to a very large sum of money. And retentions are something that are often left to one side, but really shouldn't be. Moving on then, so we've now got to the point where we've looked at the contract before the stage, we've sort of negotiated our contract, looked at sort of the risky bits, the elements of payment like interim payment, retention, and you're now post-contract. So you've signed up to your contract, you are stuck with it. So first things first is to keep an eye on payments. If there is a schedule, then that makes life easier, but if there isn't, then you need to look at the payment terms. Is your client consistently late, or are they getting later? My experience is that if a client is late in paying sort of the first payment, then things tend to get worse. They're late then on the second one, perhaps by a bit longer, and before you know it, at the end of the job, then a couple of weeks late and you're exposed. So don't let things slide. If the first payment is late, then you don't have to be rude about it, but you need to be asking the question, well, why won't it be late on the next time? What are you going to do to make sure you pay me on time next time? Looking then at applications for payment, do follow the contract, follow the schedule, follow the timings. Again, it's obvious stuff for me to say, but you'd be amazed how many people just don't do that. Another obvious thing to say is apply fully. If you've done the work, apply for all of the work that you've done. Don't sort of self-censure and think, oh, this application's a large one, I don't know if they'll be happy with that. Apply fully for it, because if you don't ask, you don't get. Do provide the backup. If you have signed up to a contract, and let's say maybe a cost plus contract where you need to provide the invoices, you need to provide timesheets, etc., then do provide them when you're making your application. And linked perhaps a bit to the apply fully point was do include loss and expense. That is one I'm frequently asked about, is do we put in our claim for the delay that we suffered? Do we put in the claim for the disruption that happened last month? Do we put it in now? Because that might annoy the employer, might annoy the main contractor. And the answer is yes, do include those loss and expense claims as soon as possible, because generally the better it's out in the open, so the sooner it's out in the open, the better. Also, there's contracts like the NEC, for example, that require you to apply as soon as possible. Yeah, you can't complain that you haven't been paid fully if you don't apply for it fully yourselves. Part of the sort of the management whilst the contract is ongoing dealing with bad debt is suspension, but we'll come on to that a bit later because it's sort of own sort of specialist topic. So that kind of covers the sort of the kind of contract management, post-contract, pre-contract. And now I do want to have a look at a situation where you've done all the bits that you should do, and for whatever reason you haven't been paid maybe fully or at all, and to look at kind of the steps that can be taken to manage that. And the first one is communication. And the thing with this is that you can do it yourselves. You don't need to employ a lawyer to do it. You don't need to incur any costs. And common methods of communication: email. Make sure it's going to the right person, copy in whoever you need to, and you don't really need to say that much initially. It's very common to just send an email, perhaps with a statement of account attached, and that will sometimes be enough just to jog somebody's memory. Sometimes late payment is innocent, and that can be enough then to push them into paying you. You may want to follow up that email then, perhaps with one which is more sort of questioning. We've sent you an invoice, we've sent you a statement of account, still haven't received payment. Please let me know when we're going to receive payment. You may then want to follow that up with a telephone call. Some people are uncomfortable with doing it, but you may want to do it yourself. You may have an office manager. But with the emails and the telephone, be polite but firm. There's no need to be aggressive. There's no need to be bullying. And in fact, I've always advised against that, because it can, can make people entrenched. It can push them back into a corner. You don't want that. Ideally, what you want is information out of them, and the information you really want is when are you going to pay me? So yeah, be polite but firm. But the key overriding thing is to have a procedure, have a sort of a process of kind of escalating where you know you're going to send the first email after the payment's 2 days of a date, then there's a second email, then there's a telephone call, and we can sort of help you with what that procedure can look like. But the key thing is to have that procedure. I'm just going to click on Q&A. Yeah, I will come back to that. Sorry, I was just seeing I've got a question. I'll come back to that at the end, and if there's any other questions. So yeah, have a procedure. That's the key thing. So you've got your emails out, you've got your telephone calls done. They still haven't paid you. What's the next step? So the next step then is to escalate it to a letter of claim, and there's two different types. Basically, there is the CPR compliant type, and when I say CPR, I mean civil procedure rule. So basically, it's the court's rule for a compliant letter. And then there's other types of letters. So we look at the court's one primarily because it's sort of the most formal. And what the court says is before you should issue proceedings in court, before you should start a court claim, you need to follow a pre-action protocol. And there's two main ones for construction. There's either the pre-action protocol for debt claims, which is where you're a business, you're writing to an individual, or there is the pre-action protocol for construction and engineering disputes. And both of them basically have steps that you have to follow before you should begin your claim forms, where you should serve the proceedings. So looking at the requirements for the letter of claim under the pre-action protocol, again, a lot of this is very sort of kind of common sense stuff, but it's the sort of boxes you have to tick. So the amount of the debt, obviously, whether any interest or other charges are continuing on that debt, details of the contract, whether it was oral or written. If it is written and the contract isn't too large, I would always include a copy of the contract, include a copy of the purchase order and of the invoice, obviously. Details of how the debt can be paid, and details of how to proceed if the debtor wishes to discuss payment options. Now, we'll come back onto this, but you may not want to include that because it's sort of giving them sort of a hint that they can pay in installments. You may just want full payment now. So that is one of the weaknesses of the court's procedure. Enclose an up-to-date statement of account and enclose the information sheet and reply form. So I don't want to go into too much detail on that. What I've done is I've sort of taken a picture of the reply form, which you can find in the protocol's PDF. And there's a hyperlink there to the PDF. It's pretty easy to Google anyway, but we can make these slides available. So you have to include that form. The other letter of claim is sort of essentially anything you want to write. And I know Charlotte has got a downloadable that we've put together. So the purpose of having sort of this different letter is to kind of give you the freedom to work outside the court's bounds. So, for example, the court says, you need to include details of interest and charges and payment by installments. Well, what I like to do is, and it needs to be used at a very early stage. It's no good if you're using it several months down the line, is to send a quick letter, which basically says, if you pay us fully now, then we will not charge any interest. We will not charge any lawyer's costs. Pay us now fully, and we call it quits. And then if they don't pay up, then you can always go and sort of move to the more formal letter of claim. But things like calculating the interest, they do take time. It does take time to put together the statements of account, etc. So it can be handy just to have a nice quick letter just to fire out the door. And in many cases, it will actually resolve a lot of the debts, and there's no need then to go to that sort of more formal, dictated content that's required before litigation. So another sort of thing that you can do yourselves, as well as sort of the letters of claim, and particularly because we're talking in the construction context here, is to have a mind on suspending your works. So under Section 112 of the Housing Grants Act, If you are due money and that the person hasn't paid you, then you can suspend any or all of your obligations under the contract. It's going to be rare that you only want to suspend some of your work. I have seen it in the past where some of my clients haven't wanted to completely destroy the relationship. So perhaps they've stopped on-site work, but they've allowed the design work to continue. It is rare. Generally, you're going to want to stop all work for somebody who isn't paying you. To be able to do that, you've got to give at least 7 days notice of your intention to suspend, and do that in writing. A point to make on this is that it is a statutory right. If somebody doesn't pay you on time, you can give them 7 days notice, and if they haven't paid within that 7 days, you can suspend. I'm stressing this because I very frequently see contracts where you might have 14 days notice, or 21 days, 28 days, whatever, all sorts of time periods put into contracts before which you can suspend work. And that's a ruse, basically. It's trying to buy more time out of you before you suspend. You can ignore that. You have a freestanding statutory right to suspend your work after 7 days. So don't be bamboozled by longer periods. So the next thing to look at in regards to suspension is what are the consequences of it? What are the downsides? Well, very little in my view. So subsection 3 basically says that you have to resume your work once you're paid in full. So when you're paid in full and you start work again, section 3A protects you in that you're entitled basically to your remobilization expenses. And subsection 4, which I haven't quoted because the wording is very clunky, but long story short, it basically gives you an extension of time for that period. So if you suspend work, you get your remobilization costs and you get an extension of time. So you're not being punished at all for suspending the works, which is why it's a very powerful weapon to be used in order to encourage people to pay you. The downside, its limitation, is that it's not for disputes. So if you apply for £100,000 and the main contractor sends you a payment or a pay less notice, let's say for £50,000, and they're saying, well, we're going to withhold the other 50,000 from you because your work is defective or something like that. It may not be a valid, so there may not be merit to the reason, but so long as there is a reason, so long as they have done their paperwork properly, then you're in a dispute, basically. It's not a bad debt as such, and so you can't use suspension. You can only use suspension where somebody clearly should have paid you, but they haven't. So bear that in mind. Moving on then from sort of the things that I think very much you can do yourselves, the suspension, the letters of claim, email, the telephoning, moving on to sort of more formal dispute resolution. Now these kind of fall into 2 categories, and the ultimate one, if you like, is litigation, and we'll cover that shortly. And then there's alternative dispute resolution, which there's a number of options, and they all have sort of their strengths and weaknesses. But let's go with litigation. So litigation is kind of the ultimate one. It is going to court. If it's a large case, you'll have your barristers, there'll be witnesses, experts, and in getting to that trial, there are various options. So there's the small claims track, there's the fast track, which shouldn't be called the fast track because it's not fast, it's just kind of the middle track. And there's the multi-track, which is kind of the all singing, all dancing sort of process where you've got your experts, and it's the full procedure. But I would say with all of them, to be honest, they are procedurally complex. There are lots of forms to fill in. There are times to meet. There are deadlines. There are fees to pay. There's a whole host of things, and often it's done in quite legal language, things like disclosure of documents, for example. Long litigation is generally long. I'd say certainly for the fast track and multi-track, you can be looking at over a year for a complex claim. It's not, it's not the case in all cases. There are things like summary judgment, which is meant to be fast, but I've got a case at the moment where summary judgment is basically where you say to the court, we don't need a trial, because the defence is hopeless. Please decide this now. And the proceedings were kicked off back in October, and the summary judgment hearing is going to be in February next year. And you know, for the court, that is lightning speed. So it kind of gives you an indication of you know, as to how long you'll be waiting. Now, costs, you know, litigation is famously expensive, you know, one of the good things, I suppose, is that costs are recoverable. The winner basically gets to get their costs from the loser. The massive downsides are that during that long period, you are paying your lawyers, you're paying the court fees, you're basically having to cash flow the process, and they're hoping to get your money back at the end of it. Costs will frequently become one of the major issues of the case. You know, in some cases, they can really amount to a very large proportion of the overall dispute, despite the court's attempts to try and sort of trim bills and the new rules on, well, not new rules, they've been out a couple of years now on proportionality. You still get massive legal bills. So what I would say on litigation is don't get into it lightly. You know, in this talk, I don't want to take you through how you go to ManyClaim online and you fill in the online form, because that's actually quite dangerous. I've had many clients over the years who have said, Ben, this particular person didn't pay us, we filled out the form online, and now we've received a form from the court and we don't know how to fill it out. And by that stage, they've already kicked off the claim on sort of bad footing. They haven't done all the things they need to. So don't get into it lightly. Do seek legal advice. If it's a small claim, you know, it might be only worth sort of $2,000 or something like that, then it's worth just getting a little bit of hand holding just to kick it off and make sure it's on the right foot. You probably don't want a lawyer to run the whole thing for you, and indeed you don't need that on the small claims track, but it's good to have a bit of advice just to steer you in the right direction, because you are getting into something which is difficult to get out of until the end. So yeah, litigation, be very reluctant to go down that route. The other options then are alternative dispute resolution. I'll come on to adjudication in a bit because it's sort of the most common other option. Arbitration, best way to think of arbitration is basically private court. It's long, it's costly, it's procedurally complex, but you get your own arbitrator. So it's a person appointed by the parties. You don't have to go to a court building as such. The arbitrator has more flexibility in the way the procedure will be run. It is all private rather than out in the open like court is. So there are advantages to it. It's going to be resolved, you know, it's going to be for disputed debts rather than bad debts. Then you've got negotiation, which you guys will probably experience, you know, most days it is just picking up the phone or emailing to try and resolve the dispute, or to try and structure perhaps a bad debt into kind of payment installments. Then you've got mediation, which is where the parties appoint sort of a third party to try and get them to do a deal. It's good for large, complex disputes. It's going to be useless for bad debts, to be honest. It is, with all the other options, arbitration, litigation, adjudication, a decision is forced on you. With mediation and negotiation, nobody can force you to do a deal. Mediation just basically tries to get you to do a deal. So of those options, because we're talking about construction, adjudication is going to be one of the most common. It is a 28-day process that can be extended. Again, you're appointing a third party, but in this case, that third party is deciding the dispute for you. You have to be bound by that decision. It's often documents only. Very rarely will there be sort of a hearing or a site visit. So that does lead to lower costs. The costs are lower compared to litigation, but they're still not cheap. Costs are generally not recoverable from the other side. So you basically have to bear your own costs. You don't get them from the loser, which can be a good and bad thing. Obviously, you've got to factor in those costs into your overall recovery of the money that you'll get there. At the same time, it means that they're not taking up loads of time in the dispute itself, which they can do in litigation. Because it's a fast process, there can be an element of rough justice. You know, if you want absolutely the right result, or at least as far as a dispute resolution process can get you that. You want to be going for litigation or arbitration, but there are obviously those downsides there. Adjudication, you can get odd results, you can get rough justice because of the speed of it. If they don't pay you after adjudication, there is a fast track court enforcement. You go to the High Court in London and they will pretty much turn it around within 28 days. So you are looking at 2 months, your 28 days adjudication, 28 days to enforce, but that 2 months in the context of litigation is still lightning quick. So coming sort of to the end of the talk, really, you've looked at your contract, you've tried to minimise the risk of bad debt. Unfortunately, bad debt has happened. You've done all of the bits that you need to do, the letters, the emails to try and resolve it. That hasn't worked. So you've now gone through adjudication or litigation. You've got your decision, basically. You've got your court order, and the person has been ordered to pay you. So what are the enforcement options? Well, basically these fall into 2 categories. The first category is where the person paying you is still solvent, they've got money, and the second category is where they are insolvent. So where they're solvent, there's a number of options, sort of perhaps one of the more dramatic ones is to send in bailiffs. You can get a High Court writ and they can go in and seize goods. It's going to be rare in any large dispute, 10 grand plus, that a company will have the assets to be able to seize. Lots of people rent their commercial properties, lots of people will have vans, etc., that are rented. The bailiffs can't take hold of those. So it's got to be owned assets that can be sold to satisfy the debt. So bailiffs, it is an option, often quite rare. If they own any property, then you can get a charge on that property. You'll often be behind the mortgage company, but it basically means that they can't sell their major assets without paying you off. Unfortunately, there can be quite a time lag between you getting that charge and then paying the property, then selling the property in order to pay you. You can apply to try and force a sale, but you're not guaranteed success, essentially. Freezing injunctions, where you can freeze somebody's assets, you can stop them taking money out of their own bank account until they pay you. The downside with that is that you need to have a certain level of knowledge of what bank accounts they have, where are those accounts, do they have money in them. And if you're claiming against an individual, you can get an attachment of earnings order, which is basically you find out who their employer is, and the employer will pay a chunk of their wage directly to you rather than them. Again, it's something you've got to go to court and get an order for. There's a whole lot of other things as well. If there is a court order against the company, it will appear on the register, it will affect their credit rating, etc. So simply getting a court order can sometimes be enough to force them to pay. And I find that if they are solvent, if they do have money, getting that court order is often enough to get the money paid over. If they don't have any money, then you're in the realm of insolvency, which is a very specialist topic, and each of the things on the screen now could probably have their own sort of talk, other than maybe statutory demand. I often hear people say, Ben, we've been told that we need to put in a statutory demand. And statutory demand is basically just a formal way of demanding the money. You give the debtor 21 days in which to pay up, and if they don't pay up, then it opens up the actual insolvency proceedings, which in the case of an individual can be bankruptcy, and in the case of a company is winding up the company, compulsory wind up the company. And if the company is wound up, it then will fall generally into 2 categories. So one is liquidation, rather. So liquidation is where an insolvency practitioner is appointed to basically dissolve the company. So if the company has any assets, they will sell them. If there's any contracts to sort of collect in, any money to collect in, they'll try and do that very quickly. But the aim of the game basically is to get rid of the company as quickly as possible and to pay the creditors out of anything that's left. Administration is a bit different, where the administrator will actually be willing to run the company and will continue to resource jobs, will continue to carry out the functions of the company. with the hope that by doing so, the creditors will be paid off. What I would say on that is that if a normally running company is unable to pay its debts, then adding the fees of an insolvency practitioner into that process is only making that situation worse. So it's incredibly rare for a company to go into administration and then to come out solvent. You often find that administration becomes liquidation fairly quickly. I do want to mention as well receivership. Receivership is particularly relevant if you're working directly for a property developer. Basically, a bank that has a mortgage on a property will have the option to call in a Law of Property Act receiver to take control of the building. And the duty of the receiver is to make sure the bank's mortgage is paid back. The receiver doesn't have any duty to any of the other creditors. So if the bank's mortgage is, let's say, 100 grand, the building is worth 200 grand, and the rest of the creditors are owed 100,000. Well, all the receiver has to do is sell that building for 100,000 to get rid of the bank's mortgage, and it's very difficult. In fact, pretty impossible to say to the receiver, oh, well, you should have marketed it in a different way to get 200 grand so that we all could have been paid. Their duty is to the bank. So be aware of that. If you're working directly for a developer, sometimes the fact that they've got a property that's being built is actually not good security, because it's the bank that will take that and you won't get anything of it. So yeah, if you're in this sort of scenario in insolvency, you need to be thinking that you're probably got a very low chance of actually getting your full debt back, and you may get back such a small amount that it wasn't worth the process anyway. But as I say, it is quite a complex area and probably worth its own talk. So that's why I'm going to draw sort of my sort of planned part of this webinar to an end. Thank you very much for listening to me rattle through all of that. At Quadrant, we do have a product that we're releasing or have released called LawHub, and that does include things like template debt collection letters, does include sort of telephone helpline, etc., all for a fixed price that can help with this sort of stuff, and hopefully support you before you get into this sort of stuff. We do sort of contract reviews as part of the fixed price, and it's why I wanted to emphasize sort of the start of the talk. How can you avoid bad debtors in the first place? Because the reality is, if you get all the way down to here, and I've sort of minimized my screen there, if you get all the way down to this sort of insolvency option, then you're in a bad place, and recovery is going to be unlikely, to be honest. So what I need to do now is I need to go back and have a look at the questions and the chat. So yeah, Charlotte has very helpfully put the debt collection letter template in the chat there. So do feel free to get hold of that and use it. If you need a Word version, then just ping me an email or we'll send you a Word version, but the PDF should be editable. So I've got a question here. How should we protect ourselves if we're halfway the job under contract and we find out that the customer has a financial problem? What are legal rights in this situation? Well, it's a good question, and it's going to be very common, essentially, because sometimes looking at credit safe, looking at Companies House may not reveal the problem that's hidden, and it then becomes apparent when you're halfway through the job. So just because a client is, you think they might be dodgy financially, isn't a good reason for breaching the contract, bringing the contract to an end. They do have to commit a breach of contract for you to be able to terminate, and then you've got to follow the contract's procedures properly to be able to do so. Generally, I would say that if you think they're starting to struggle financially, then you need to be, absolutely laser focused on when they are paying you. You know, if they're a day late, you want to be escalating things very quickly. I've had a client in the past who had a difficult client, and so they sent you know, a notice of intention to suspend. And I see Zach has sent me a question, which I'll come on to. You know, they sent that notice pretty much every month because the main contractor had enough money basically to actually move the job on. They just didn't want to pay the money out, so they sort of kept on limping along. Be very careful about committing more resources to that project. You know, if they are trying to instruct variations, for example, well, often there'll be a clause that says that you've got to carry out variations that are sort of reasonably within your competence. Well, you'll want to be sort of interpreting that kind of clause very, very narrowly. Don't commit more labour. You know, it's very common for difficult projects to be screaming at you. We need more guys on site, more operatives on site. We need more resources. This work's available to you. Well, you need to be tough, and you need to say, well, look, this project's only delayed because of X, Y, and Z. It's not our fault, and so we're not going to commit more resources. We're going to commit our original planned resource to this job. You know, self-help is always better than incurring a load of cost and then trying to get it back afterwards. So hopefully that's given a bit of an answer there. You know, I can't obviously deal with any specifics, but it is a difficult one. You know, it is common in construction for companies to run into difficulty halfway through a job. You know, particularly if that job is a big one or it's unusually complex for them. They don't have the skills, they don't have the management. In which case, you know, as I say, be very keen on when they're paying you. When it comes to your applications, make sure your applications are fully loaded. Put in your loss and expense claims. Yeah, then as I say, protect yourself as far as you can by limiting your expenditure. So yeah, the question from Zach then is to do with suspending works, and the contract says we cannot suspend for 14 days. Is it to be ignored? Yeah, absolutely, ignore it. And when you suspend work, don't write, you know, we are just flip back. Don't write we are, you know, writing to you under clause 36 of the contract to suspend our works. Put in the letter, you know, and we can provide you with the templates of this. We are writing under section 112 of the Construction Act, and we're suspending under that, and we're going with our 7 days rather than the longer period that you've put in your contract. And I'll say that's, don't be bamboozled by the longer periods in the contracts, because it is a common thing to see. So I think that's the questions I've got for now. If anybody else has any more, do feel free to post them in the box. I'll let the webinar run on for a little bit just in case there are any. Would it be legal to ask for payment in advance? Yeah, absolutely. You know, that is a very good that's a very good question, and perhaps I should have dealt with that in my slides. So advance payment is perfectly legitimate pre-contract. Now, if you're in the middle of a contract, you're already signed up to it, which seems to be the scenario you're talking about, then you can't dictate that they need to pay you in advance because you're already locked into the payment terms of the contract that you signed up to. But if they have a pattern of late payment, they're obviously in breach of contract, then you may be able to have these sort of recourses like suspension of work. And you may be in a position to say to them, well, look, rather than suspending work every month and stopping the progress of this job, we will continue to work, but you need to pay us in advance for these certain things. The best solution when it comes to advance payments is again, it's back here, it's back at the contract stage. And if you are seeing things like you know, a bad credit rating, if they are taking on a job that's too big for them, then you know, advance payment at that point before you enter into the contract can be very powerful. And you'll do it naturally as a matter of course if you've got sort of big materials packages, air handling units, perhaps a large piece of frame, steel frame, something like that. You'll naturally want advance payments to cover those big ticket items anyway. But there's no reason why you can't extend it to other items if you think that they're dodgy. And it's something that we lawyers do. If we've got a large claim for somebody, then we'll often ask for money on account, not the whole amount of what we think it will cost, but just a portion to balance our risk. And yeah, you should be considerate pre-contract. Once the contract's entered into, as I say, you've got less options because you are already bound to a particular sort of payment regime. And so you'd be relying on negotiation, basically, to alter the terms. Oh, you're very welcome. Anything else? I'll give you a minute or two, and then we'll wrap this up. Fine. Well, look, I think that is the end of the questions for this this session. This is something which I quite enjoy doing. I hope it's interesting for you guys. We're wondering at the moment whether to continue them in the future. So if you've got any feedback that you want to email us or message us, then do so. If there's a time that's more convenient for you, if there's topics that you want to hear about, then let us know and we'll cover them. And in the meantime, I'll thank you very much, guys, for tuning in. And yeah, I'll see you in the next one. Thanks very much.